Hi, I'm Don Banowit, a director with the intellectual property law firm Sterne, Kessler, Goldstein Fox. Today, I'm going to discuss two recent clarifications to the deadlines for filing a petition for inter partes review at the United States Patent Office. Under the American Invents Act, inter partes review is available to challenge the patentability of one or more claims of an issued patent. By statute, a petition for inter partes review must be filed within 1 year of service of a complaint alleging infringement of the patent. This requirement demonstrates a clear preference for early resolution of patentability challenges brought in connection with concurrent patent litigation. Recently, the Patent Trial and Appeal Board was presented with the issue of whether a petitioner was barred from seeking inter partes review where the petitioner's parent company had been served with a complaint alleging infringement of the same patent in a prior litigation more than 1 year prior to filing of the petition for inter partes review. In determining that the petitioner was not barred, the Patent Office focused on the fact that the prior litigation had been voluntarily dismissed without prejudice pursuant to a joint stipulation. The Board concluded that the effect of such dismissal was to leave the companies as though the action had never been brought, thereby nullifying the alleged service of the complaint. The Board also based its decision on the fact that in the prior litigation, the petitioner's parent signed and returned a waiver of service, but the plaintiff never filed the service waiver with the court. Accordingly, the Board concluded that the patent owner had not established a service date in the prior litigation. Having decided that the petitioner was not barred by the prior litigation under either rationale, the Board did not have to address the issue of whether the petitioner's parent was the real party in interest or was in privity with the petitioner. The contested proceeding is IPR 2012-00004, and the Board's decision is dated January 24th, 2013. The American Invents Act also mandates that inter partes review cannot be sought during the first 9 months of a patent's issuance. This waiting period was designed to prevent parallel inter partes review and post-grant review proceedings, as post-grant review proceedings are only available during the first 9 months after a patent issues. However, post-grant review proceedings will be largely only available for patents issuing from applications filed on or after March 16, 2013. Even though currently issuing patents are not eligible for post-grant review, under the plain language of the law, potential challengers still would have to wait 9 months before petitioning for inter partes review. Fortunately, this so-called dead zone was eliminated earlier this year by a technical amendment to the American Invents Act. The technical amendment clarifies that the 9-month waiting period shall not apply to patents not eligible for post-grant review. Accused infringers and patent owners will have to be mindful of whether a newly issued patent is eligible for post-grant review and will have to carefully consider the facts regarding any prior service when determining the applicable deadlines for filing an inter partes review. Thank you.